All right, we're going to continue the conversation now. We were talking about, and we'll continue, the Adrian Peterson case. We talked about the line, and the panel in front of me didn't agree with me the last segment that we really should be telling parents where the line necessarily starts and stops with everything, and there's some judgment calls in that. Well, let's bring in our panel right now and see if they all agree with us here. Jimmy Kasouris, criminal defense attorney in Manhattan, lecturing at New York Law School, a visiting professor at the University of Birmingham in England. He's come across the pond to join us tonight. Doug Von Oist, founding partner of Carson Von Oist, focusing on corporate misconduct, elected as one of the legal 500 most powerful and influential trial lawyers in the nation. Notice I said powerful too. Mayo Bartlett, attorney and former chief of the Bias Crimes Unit at the Westchester County DA's office. Just a good guy. And Mark Furnish, a professor at Brooklyn Law, and he has argued, unlike anyone at this table, at the highest court of the land before the Supreme Court.
They don't call me the high-powered lawyer.
No, that's right. Okay, all right, guys, I want to get right into this. We had a good fight last time. Nobody getting along here tonight. I looked up we heard what in Texas, the prosecutor bringing the case against Mr. Peterson had to say. I also looked at the statute in New York. It basically says you can do what you want to the kids until you really shouldn't do it. It's vague. Now, I've already said not everyone agrees because different people can disagree how you're going to discipline your kids. So I don't want to get in that fight. But is there a line? No one's going to tell me that a 4-year-old can defend himself physically or through a court of law. Where is the line, or is there one, where you can or can't discipline your kid? Can you take a switch and work your kid over on the backside, or it's okay unless blood draws? Where's the line here? Anybody?
Assault. You know, there are criminal statutes that criminalize certain conduct, and our children are no less individuals than anybody else that we encounter.
But Jimmy, I'm not, as much as I was tempted, I haven't taken a tree ranch to you. Okay?
That's what I'm saying.
If it does, I'm going to assault.
That's what I'm saying.
If you all of a sudden go home and one of your kids drives you nuts here and you take a switch to your kid, I'm not sure if you've committed a crime or not. And there seems to be, and you could argue, you can defend yourself a heck of a lot better against me than a kid could to you. So where is that line? I'm still confused.
The line, I think, needs to be in the extent of the force used. You have to take into consideration how old is the child. Like you say, you know, when you take a weapon and you strike a 2-, 3-, 4-year-old child, there's a big difference from taking a branch and getting a 13 or 14-year-old and hitting him in the butt and saying, get upstairs. If you look at the injuries on this child, these are real injuries. You know, you get prosecuted for assault when you do that. But still,
you're making a case to a jury to say where it is. I still don't know. You got to charge me. I'm the jury here. Where's that line, Doug? Where does criminal and just parenting start and stop?
Well, you're looking for the line. If you said you looked at the statutes, if you look at Texas...
In fact, we can bring it up here if you want. The New York statute.
The Texas statute is pretty much telling you what you can do. The New York statute is telling you what you can't do, both vague.
Well, in fact, you're talking about Texas. Could you bring up Texas, guys, as Doug's talking? This right here is where it says, Doug, for parent or step-parent, the child is justified to use non-deadly force, tell me what that means, against a kid under 18 when and to degree the actor reasonably believes necessary to discipline or safeguard or promote child's welfare. Basically, do whatever the heck you want, don't kill him.
Yeah, but you see what you're looking at is you're looking at somebody was talking about regional in the other segment. What they're saying is the statute's going to reflect the community. And so you're going to have a statute that says in Texas what they can do if it's justified. And if the jury
what's justified?
Well, you're not going to get that because now you have to get a jury to listen to the facts. And they're going to say, all right, yeah, I believe taking a stick and hitting a guy is justified. That's what we all do. You're looking at a regional problem.
And I'm just as confused as when I started this. So Mayor here, I'm going to get even more confused. I heard that 85%, it was just quoted to me in the last segment, of the African-American community in the southern part of America disciplines their child with an object, whether it be a switch, extension cord, I heard, or whatever else. Charles Barkley said you're going to arrest basically everybody down south if you were to try and prosecute this case. It's a regional and a racial thing. When you hear that, what do you say?
Well, I think that the statistics are always boggle my mind. I don't know who they talk to, who the 85% are. But it's a generational issue also, because if you go to my parents' generation, their parents, they would routinely tell you everybody would have been a predicate felon because everybody would have been arrested because anybody that told you that if they spanked you, if they hit you with a belt, it doesn't mean that they drew blood, it doesn't mean that you left a mark. And I think the key is, if you go back to the Texas statutes, reasonableness. So if you have Adrian Peterson, who's this hulking guy, great athlete, phenomenal athlete, but you got a 4-year-old kid. So for a 4-year-old child, Adrian Peterson doesn't need to use anything. He probably doesn't even need to hit that child. He probably could grab the child, talk to him, look into the kid's eyes, and probably get that point across. And if you do it properly, you may never need to hit that child. So I think that clearly, for him to get a belt or a stick or anything else to hit this child and to leave, as Jim said, the injuries on the kid, on his genitals and all over his body, it's way beyond what's reasonable. And I don't care what your race is. It's just there's no calling for it for a 4-year-old child.
You know, Mark, I said in the last segment, I go by the one guy on the block rule, which is wherever I've lived, I've known one guy that I wasn't comfortable with having a gun. There's one guy I wasn't comfortable knowing where the line was, where to hit or discipline the kid. And to me, when you have discretion, as wide as a semi could have drawn through that statute in Texas, you're going to lead to all this confusion where you don't know where it is and where it is. We don't take everything our parents did and it held. Look at some of the social issues. Look at the velocity of gay marriage that moved in this country. Look how it used to be acceptable to talk to gay people in this country, let alone people of color, that is, if not criminal, totally ostracized by society nowadays. Explain to me how we can have so much discretion when it comes to this and argue one generation to the next, things should stay the same.
Well, I think it goes back to what Mayo said, because reasonableness is a special word in the law, because the law hypothesizes the existence of an objective standard, i.e. the hypothetical reasonable man or reasonable person. So that's why you have a jury drawn from a fair cross-section of the local community. They're going to speak as to what's reasonable in that community, what's
with all due
objectively
respect, Mark,
reasonable.
some 4-year-old kid in East Texas versus some 4-year-old kid in Southern New York, they got two different chances, or in terms of making it out of that house here without walking, with a limp here for a month.
But that's the way it should be, because that's the way the federalist structure is set up. What's reasonable in Texas is going to be different from what's reasonable in New York.
So safety's predicated on geography?
No, there's a difference between safety and punishing somebody under the means of the criminal law, which imports a moral wrongdoing component to it. Nobody's coming out and saying, oh, well, Charles Barkley aside, what he did was commendable or laudable. It's just that different areas of the country have different practices.
And by the way, a whole bunch of NFL players have come out in support of what Adrian Peterson said to basically stay out of it. I heard the same argument, by the way, with dogfighting. Hey, it's a regional thing here. You know what? We do it where we are. Now, Michael Vick went to jail.
You don't have a right to discipline a dog, even if you assume that it's a chattel, a piece of property that belongs to you. That's a different thing about beating up somebody who's outside the nuclear family.
Stay with me, guys. When we come back here, I'm going to keep this conversation going. And also, I want to know, does Ray Rice have a case on appeal? Because he's bringing one right now, saying double jeopardy and a whole other bunch of other stuff. We'll talk about those cases after this.